Good morning, everyone. Thanks for being here. My name is Renee Lindsay, and I'm the CEO for the Fortuna Chamber of Commerce. And with me is Dave Turner from HR Direct. Good morning, Dave.
Good morning, Ray. Nice to be with you and everyone else.
Yes, thank you so much for doing this. Before we get started, I just want to read a short disclaimer. This webinar is provided for general information purposes only and does not constitute legal or professional advice on behalf of our panelists or the Fortuna Chamber of Commerce. We encourage anyone watching to obtain proper legal or other professional advice specific to their situation before taking action on any information in this webinar. All right, so let's get started. You ready for our first question?
I am. Let's go.
Okay, so I'm going to speak as if I'm a business. So now that I am reopening, I offered a job to one of my laid off employees. They said that they didn't want to return to work right now as they were making more on unemployment than they would be working for me. How should I handle this situation?
Well, in effect, if they're refusing a job offer for you, they are in effect quitting or abandoning their job. So, what I would say to that former employee would be that you understand their position. They're in kind of a difficult position, as many people are. But that, and should there, in the future, should they wish to reapply for another position with your company, they're certainly welcome to do so. I would then confirm that conversation in a letter to the employee, and in that letter, I would say that this confirms that we made you a job offer on such and such a date. I put in the terms of the offer, the job, the wage rate, the hours, the start date, and so forth, and also indicate that as part of that conversation that the employee had declined to accept the job offer. And then you'd send that letter to the employee, and if down the road they wish to reapply, that's fine, but they have declined a job offer. I guess the question that you are then faced with is whether or not you want to send that copy of that letter to EDD. Because in effect, the fact that they've turned down available work would normally preclude them from getting unemployment benefits. And so if that is something that you're interested in doing, then I would make a copy of that letter and send it off to EDD and let EDD do whatever they're going to do. EDD may decide to continue benefits or stop benefits, but that's up to them. But your responsibility would be to have spoken to the employee and put it formally in writing, and then send a copy of that to EDD. So that would be my course of action.
Right, and that's a good point about making sure that you get it in writing. Do you think a formal, like, mailed letter is good, or could we do an email? Is that sufficient? Would that even be better, because then you actually have a sent copy of the email?
Actually, I think a letter like that probably is better by old-fashioned mail, but I would send it like certified, okay, and return receipt requested, so that you have a record that it was delivered to the employee.
Got it. Great. Okay. Next question. I understand that Governor Newsom recently issued an executive order on workers' compensation. What does that do, and what does it require on my part?
Okay, so this can be or may be a fairly large deal, or may not be a fairly large deal. But what this is all about is that the governor did issue an executive order in which deals with workers' compensation. Now, to back up 1 second, normally workers' compensation is what is called a no fault. In other words, when someone gets hurt at work, we don't try and decide whether they did something wrong or not. They're covered. Okay, and so there's not typically a dispute as to fault with respect to an injury or illness at work. What this executive order, and in that situation, typically, however, the employee must be able to demonstrate that their injury or illness did happen at work. And the onus of proving that or demonstrating that is generally on the employer or the employee's medical provider. What this executive order does is sort of reverses that with respect to coronavirus cases, and says that if we, under certain conditions, and then there are 4 of those, and I'll talk about those in a second, under those 4 conditions, if an employee has the coronavirus, it will be presumed to have been work-related and therefore covered by workers' compensation. So there's not going to be going into all of this, well, where did you catch it? Did you catch it by going to the drugstore, or did you catch it by coming to work, and having that disputed over and over and over again, which would be terribly complex and difficult. So the presumption of this work order or this executive order is that an employee who meets, these 4 conditions, the employee, and I need to read these for a second. The employee tested positive or was diagnosed with COVID-19 within 14 days after being at work. So that's one condition. Number 2, the date above was on or after March 19th of this year. Number 3, the employee place of employment was not the employee's home or residence. So if this employee were working at home, for example, that would not be covered by this executive order. And 4, the 4th condition, if the employee was not initially tested positive, but a positive diagnosis is confirmed within 30 days of diagnosis, then it would also be covered under this executive order. Now, this executive order at the moment only applies for cases that fall within a 60-day period from May 6th to July 6th. So if it is beyond, if it's a case before May 6th or after July 6th, it would not be covered by the executive order. But remember that as an executive order, the governor may extend that, and it's totally up to him. And so while we think this, or while at the moment this expires on July 6th, it may very well go beyond that, and we'll just have to stay tuned to see if it in effect does that. So what does that mean for you as an employer? I think it means several things. First off, I think it means that you do need to have a written COVID-19 protection plan in place that talks about all the things that you're going to do, to protect your employees, because that will be the first line of defense, if you will, that what were you doing, to offer protection to your employees. So I think the written plan is extremely important, and we'll talk a little more about that, I think, probably later in the presentation. I think it's also important that you have some contact with your workers' comp broker or carrier and understand what their position is. So I think it's important to have a very good working relationship with your carrier. The third thing is with respect to the DWC-1 form, which is the employee claim form that you normally, when an employee has an injury, you give them a DWC-1 form, they fill out their portion and give it back to you. I think it is important in this situation, if you become aware, of a COVID-19 case from one of your employees that falls within this category, you should give them a DWC-1 and tell them that your understanding is that perhaps their illness is maybe work-related, and if they wish to fill out a DWC-1, they should do so and return it to you. So that kind of covers your base, that you've done your responsible thing. Should it turn into a final case? And there's also a question about the Osha Form 300. The Osha Form 300 is where you enter your injuries. I think from what I can find at the moment, it's a little up in the air as to whether or not you need to record this injury. I think the safe thing is probably to do is to record it, and maybe you want to just stay tuned to the Cal OSHA website and see if they issue more direction. But that would be a bit of an open question, but I think the conservative and safe thing to do is probably to list it, on your OSHA 300. And then finally, you need to be careful with respect to these claims. You may have a raised eyebrow about whether it's a legitimate claim or not. You want to be careful not to do anything that might be looked at as being discriminatory against an employee who has such a claim. California takes very strongly what are called 132A claims, which means an employee is protected from discrimination by filing a workers' comp claim. So if you were to do anything to this employee as a result, or maybe as a result of his filing a claim, you'd be subjecting yourself to a discrimination claim, and I don't think that's something you want to do. So that's what the course of action I think you should follow.
Great. And did I read something about a 14-day challenge period that employers have?
Yeah, there is a 14-day challenge period in there, but and the reason I'm not really emphasizing it, it's just going to be very difficult for you to challenge it. For you to take the position that if the employee fell into this category of when this illness started, for you to say, well, your neighbor had it, or I know you went to the beach and the people weren't doing social distancing. It just seems to me like an awful waste of your time with all the other things you got to do.
Yeah.
But yes, there is. You can dispute it, and it's just the presumption that it happened to work. So yes, you certainly can dispute it, but I think the likelihood of you being overly successful with that is, may not be a worthwhile expenditure of your time.
Great. Okay, great. Thank you. Next question. Do all employers need to have a written site-specific COVID-19 protection plan?
Yeah, I think the answer to that is yes. And for, there are probably several reasons why, but a couple of them include, first off, the Osha thinks that you should be, requires you to update your injury and illness prevention plan with a COVID-19 section. So that's one reason why you really need to have a plan. Those of you who are in the reopening phase and submitting a plan to the county to get reopened know that as part of that process, I believe you need to have submitted a protection plan. And I think it is just for the betterment of all, okay, that such a thing is in writing and your employees are aware of it, and you're aware of it, and you enforce it. So I think it's a requirement, and I think I would strongly urge everyone to have a written plan, even though those can be somewhat painful to create. But there are a lot of resources out there, including the county, who I think has issued some draft plans that Renee, you have. Also the CDC and OSHA, and there are a number of sites that offer a lot of good information on what should be or may not be included in such a plan. But yes, you should have such a plan. And along with that plan, there's also a posting requirement, okay, that with respect that there's a Department of Labor posting that with respect to some of these issues that you must also post in your workplace, like you do your all-in-one poster and all your other postings.
Yeah, and that OSHA poster is free. You can download that. It was also in one of our earlier newsletters, but I could try and find that while we're doing this and stick that information in the chat, and we'll include that down below the video when we post this to YouTube. Okay, next question. I have non-exempt hourly employees working from home. Do all normal wage and hour rules apply? For example, overtime, meal and rest breaks. Do I have to reimburse such employees for expenses they incur while working at home? Office supplies, electricity, telephone, cell phone fees, and then how could I create a teleworking? Is that the one I want? Yeah, telecommuting. That's the word I wanted. Policy and is that necessarily recommended?
Well, first off, with respect to the labor laws for non-exempt employees, the answer is a resounding yes. They all apply. Overtime, meal breaks, lunch breaks, everything that is in the labor law with respect to treating non-exempt employees falls into place. So if you have non-exempt employees teleworking, they need to be keeping their timesheets. They need to be showing their meal periods. They need to do everything they are doing as if they were working at your physical location. And there's no exception to that. So you're right, overtime must be paid as it is required, and meal breaks and lunch breaks. There also is a requirement to reimburse employees for expenses that they incur while they're doing their job. There's a California Labor Code, I think it's 2802, that requires employers to reimburse employees for their expenses. So the things that Renee mentioned, cell phone portion of if they're using their cell phone for work, or if they're using the internet for work, whatever expenses that they are incurring while working at home are reimbursable. Now, I think the easiest way to do that, okay, is I don't suggest that everyone try and get an itemized list. I think that is painful and difficult. My suggestion would be that each employer arrive at a reasonable monthly fee, say $50, $75, and make that determination that you are going to, that will represent reimbursement for their normal expenses. It's a stipend, and you're just going to pay it once a month. In doing so, the one caveat I would offer is to say to the employee, if in any period your expenses exceed the stipend, please contact me. So that if it does go over, the onus is on the employee to contact you, that they had to do something that resulted in their expenses being more than the stipend that you're offering. But I would do that, and yes, I do think it's important to have a written teleworking policy. I think that covers kind of a number of different areas, including starting and stopping teleworking and the employee's responsibilities, your ability to stop them from teleworking and coming back to work. All those sorts of things are important. And you also would make reference in there to your reimbursement or their stipend for their expenses. And so, yeah, I think that having a teleworking agreement that you have signed with the employee is something that is very important.
Great. Okay. All right, next question. This is regarding the sexual harassment training mandate. Has the state delayed the requirement for employers to complete this training in 2020?
No. Wishful thinking for everybody. No. I mean, that may happen, but I wouldn't be holding my breath for that at the moment. And no, they haven't at the moment. So the requirement remains in effect that for employers who have 5 or more employees, they must provide 2 hours of harassment training to their supervisory managerial group and 1 hour of harassment training for all their non-supervisory group. And that date is still before the end of this year. So unless we see some change in that, that requirement is still there. Obviously, we're in May and December is still, 7 months down the road. But with all that you have to do, you should at least keep in mind that that is a requirement that is unchanged. Clearly, it's more difficult to do in these times because the different types of venues that are used for this training are not available to everyone at this time. But hopefully that'll open up. If it doesn't open up, maybe they will change the date. But at the moment, that requirement still remains, and you're going to have to put it on your calendars and probably try and get it done before the end of the year.
Do you know, our webinars are as long as they're interactive, where attendees can ask questions, is that considered okay under the current legislation?
Yes, as long as
assuming that. Okay.
Yeah. Yes, as long as there are webinars. Cal Chamber has one, for example, that fits the bill. And you're right, as long as they meet certain criteria, like that they're interactive, that the participants can ask questions and get their questions answered and be tested a bit on the criteria, they would meet the requirement. And certainly the Cal Chambers training sessions would meet that obligation. And I think they offer both the 2 hour, and the 1 hour session. So I think that is a way, for you to do it.
Right. Yeah, I know you and I had discussed offering that to the Fortuna Chamber members, and then we got derailed with the pandemic. But
we did. Hopefully, we'll be able to do that at some point this year, but we can't at the moment.
Right. Well, maybe we'll just have to get you on Zoom now that you're a pro at it.
Yikes,
okay.
That would be.
Okay, next question. If I want to take employee temperatures before allowing them to work, can I do that? What type of documentation is required, if any? And do I have to pay them while they wait and get their temperature taken?
More good questions, Renee. Yes, so yes, you certainly can take employee temperatures. There are no prohibitions from doing that. If you do, however, I think there are some areas for you to be careful about and watch out for. First off, again, I think there needs to be some kind of a written policy. Okay, for example, how is this going to be done? How are the results going to be dealt with? And who's going to do the testing? All those kind of things I think would be helpful to have written down someplace. There is a single requirement that there's some language from the because this ends up being a bit of a privacy issue. There is some language from the California Consumer Privacy Act that must be posted if you're going to take temperatures. That's some language I can send to Renee, and if she doesn't have, and she can make it available to you. That should be posted. I'll just offer, and this is a personal opinion, okay, and I'm not convinced that of the value of temperature taking. I know that early on, when we first started all this, that one of the symptoms was a temperature, above 101 or something or other. I'm obviously not a physician, but I'm not sure that's the case anymore. So that the raised temperature is indication of much of anything, and there may be many people who are non-symptomatic who carry it. So I'm not quite sure of the value of it. the other issue with this is I think that it would be, if I were to do one, I would do it on the basis of either pass fail. Okay, I would not be recording everybody's temperature. But if you're then going to have a fail, you need to have in your written policy, well, what do you do when someone fails? Does that mean that you send them home, that you require them to stay home for 72 hours or whatever? So that's all part of that policy that I think that would be important to write. Is it necessary to keep these test results? No, it isn't necessary to keep the results. And particularly if I were recording an employee's temperature, I wouldn't keep them because it's medical information. And medical information is subject to all kinds of privacy laws. I think if you were to do something like that and record the temperature itself, that you'd have to file it in the employee's medical file because it's medical information. And I just think that is extra onerous. Yes, this would be, if you're requiring an employee to have their temperature taken, that would be work time. That would be paid time. So if they were, while they were getting it done, or waiting to get it done, all would be considered paid time, and they should be remunerated for that. And clearly, if someone is the person who may be taking the employee's temperatures, that person needs to be trained. That person probably needs to have extra PPE in because of what they're being asked to do. And that person needs to clearly understand, the nature of the privacy of this issue, that they could not in any way, shape, or form give any kind of communication with respect to, Dave's got a temperature today, or Dave failed the test today and we had to send him home. I mean, this is because it's medical information and because privacy laws are so strong in California that whoever is involved with this process, needs to really understand the importance of privacy. And therefore, in deciding to do it or not do it, I just suggest that you weigh the pluses and minuses of doing such a thing and how it would be treated. But you certainly can do it, but there is no requirement to do it.
Okay, great. So I think in this situation, less documentation is better, but I do appreciate the caution regarding confidentiality, especially when somebody, does spike a fever and they come in, that the person who's doing the temperature taking should keep that quiet. But that does roll into one of our questions, which I'm going to move forward since we just talked about that. Can I require an employee who says that they tested positive for the virus provide me with a signed medical provider statement verifying that claim?
No, you cannot require that sort of a statement. One of the things that they did when they passed these laws was that they understood the stress that the medical community was under to take care of all this, and so they wanted to ensure that the medical provider community was not bogged down by every Tom, Dick, and Harry, if you will, asking for a written medical slip saying I've got COVID-19. So you may not require an employee to provide written proof from a medical provider that they have disease. What you can ask for, and you should ask for in a situation like that, is the name and contact information of the medical provider, that provided the diagnosis. And you should have that recorded somewhere. And because at some point in time, I think this documentation on many of these issues is going to become a lot more important than it is today. So you can ask for the name of the provider, their contact information, but you cannot require that they have provide a written documentation that they are tested positive or that they have been diagnosed with the disease.
Okay, great. And also tagging onto that, if I have an employee who tests positive for the virus, we've already talked about maintaining that confidentiality, but how do you do that in a way that protects your other employees? In particular, if, not so much with the temperature, if somebody has a fever when they come to work, but if they actually test positive, how do you maintain that confidentiality for them, but also alert your employees? Is it best to just report it to public health and let public health deal with that, with the contact tracing? What do you suggest?
Well, my suggestion would be, yes, your first contact is public health. I do think you have the responsibility to your other employees to tell them that there has been a positive test or a diagnosis, from a coworker in their work area. And this also would be part of your written plan we talked about earlier, that what you would do in such a situation. So I think you do have the responsibility to inform your employees that there has been a positive test. The critical thing here is not to identify who that employee is, to maintain that employee's privacy. Now, it may be totally obvious to everybody in the world. I mean, if you've got 3 employees, okay, and one is missing, okay, and you're talking to 2 others, it's pretty obvious who may have who the employee is. But it is critically important, absolutely critically important, that you do not identify that person by name. And the other 2 employees can surmise, all they want to do. But anyone in any kind of a management, supervisory area of responsibility should be absolutely alerted to the fact they may not ever disclose the name of the employee who has tested positive. That right to privacy is sacrosanct and needs to be protected, even if it's totally obvious who it is.
Okay. Yeah. If rumors and speculations happen.
Yeah.
Between the employees, that's, yeah.
You can't stop that from happening,
right.
But you can certainly tell anyone who has any kind of managerial supervisory responsibility that they have a responsibility to never disclose the name of that employee.
Great. Okay, so now we're going to shift, also related to worker safety, but we're going to shift over to the personal protective equipment.
Yep.
So if I require my employees to wear masks or other PPE while working, do I have to provide that equipment? If they come in or they keep saying, oh my gosh, I left it at home, what are my options? Can I charge them for additional equipment? Can I send them home to go get it? Do they have to be paid to go back home and get it because it's now required, similar to a uniform? And then also what happens if they don't maintain it properly, like they would have to maintain a uniform? Can I charge them to replace it? So let's use the example of washable face masks that some employers are buying and for their employees. If it becomes frayed or dirty, or you can tell it's the same one they've worn 3 days in a row, what are my options as an employer?
Okay, so the first question is the employer responsible for supplying PPE that they are requiring employees to wear while at work? And the answer to that is yes. Okay, it's just like if you have a high noise area and you require your employees to wear hearing protection, you have the responsibility to provide hearing protection. The same thing is true here. So if you are requiring your employees to wear masks, gloves, or any form of PPE, that you are responsible, for providing it. Now, let's talk about an employee who comes to work and says, oh, I forgot mine at home. Well, you have to wear masks to come to work. So you're not prepared to go to work, and we're not going to put you to work because you don't have your personal protective equipment. So yeah, I think you can say, go home and get it, and that would not be paid time. That's an employee who came to work unprepared to work. I mean, if you have another mask there and or a pair of gloves or something that's fairly simple to do, you might just give them one. But you certainly could say, we gave you a mask. You need to come work with it. And if you don't have it, then go get it. And when you come back, you can go back to work. I don't think there's ever a situation, any of these situations, and you alluded to a couple of them, where you could charge the employee. Okay, that's not going to work. You can discipline an employee. Okay, if your part of your policy we're issuing you a mask and you need to maintain it in a proper order and wear it in a proper order, and an employee doesn't do that, I think you can discipline that employee and tell them that they are in violation of your policy for not maintaining their personal protective equipment, and failure to do so will lead to further disciplinary action. But your hammer here is discipline, not charging the employee. So you're just not going to be able to get away with, I think, charging the employee for a extra mask. If your policy were such that you felt that a person could wear a pair of gloves for 5 days, and you had an employee going through gloves every 20 minutes, again, I think you may be able to, have some disciplinary action for not properly maintaining their protective equipment, but it's disciplinary action is not charging them for using extra gloves. So, you kind of get that your hammer is disciplinary action, not being able to charge the employee for, abusing the equipment or not wearing the equipment or whatever. Were there other parts of that question I may have?
Just if they don't maintain it properly.
Yeah.
Can you charge them for replacements or extras? So, if we look at face coverings, like cloth coverings, obviously you don't want just one if you're working 5 shifts a week because you don't have time to clean it. So, so let's say an employer gives you 5, but maybe you want 7. Is that something that they could purchase?
Yeah, I guess so. It's a tricky area to be charging employees for personal protective equipment, and so I would try and sit down and have a discussion with the employee and understand why they felt they needed 7 and so forth. And in the end, maybe it's easier to give them 7 and move on if they have a reasonable reason for doing so and so forth. But I think that while if someone says, well, I want 10 or I want 15, could you ask them, well, then you need to purchase those? Yeah, perhaps you could, but it needs to be pretty clear that this is a voluntary acquisition on the part of the employee and not something that you're kind of charging them for.
Yeah, it might be easier just to send them to one of our local businesses who are selling cloth masks and have them purchase them direct. Yeah. Okay, great. Next question. I have an employee who is currently teleworking. My business will be reopening and I need that employee to return to our office to work. However, the employee says that they are too scared to do so and want to continue working at home. Do I have to let them? Or can I require them to return to the office?
You can require them to return to the office. And so you do not have to, because you have allowed someone to telework, during the crisis, you've now decided that period of time is over and you want the person to return to the office. You have every right to require the employee to return to the office. And should they say, well, I can't do that, or I don't want to do that, that is in effect the same as a quit, and should be dealt with in sort of that same manner that you've offered. Their job is now gone back to work, being the requirement being working from the office, and therefore on such and such a date you're going to be expected to return to the office. Again, I would sort of document that in a letter to the employee that said that you had this conversation in which you indicated that the time for teleworking was up and that you expected them to return to the office on such and such a date to perform their job duties. Your understanding is that's not something you wish to do, and therefore you're going to treat their situation as a voluntary resignation. So clearly that is something that you can do. I think that this emphasizes the importance of having a written teleworking agreement, okay, because in that written teleworking agreement, you would have said up front that this is for a short period of time or a period of time covered by the virus situation, and that when that period of time is up, that the employee understands they would need to return to work. The one exception I guess I would make to this would be if someone were to have a disability that was covered by the Americans with Disabilities Act. And if they were to say, well, the reason I need to continue to telework is because of my disability that qualifies with the ADA. If that were the situation, the employer would be in a situation of needing to sit down with the employee, discussing their situation and seeing and going through what we call the interactive process to decide whether or not there is a, quote, reasonable accommodation that needs to be made so the employee can fulfill the essential job functions of his or her position. But as part of that process, I guess I'd say that teleworking, might be a reasonable accommodation in that situation, depending on the circumstances. But that's the only exception that I could see to you being able to, in effect, demand that an employee, return to work. And certainly, if the employee said, "Well, I'm scared," that is not a ADA disability, and certainly would not trigger, that exception. I think you can clearly say you understand. Okay, you understand that you're not being critical of them. You understand where they're coming from. Understand the fear. Understand they may have aged parents at home or whatever, and they're afraid that they're going to get it. You understand all those things, but they also need to understand that failure to do so, to return to work, is in effect abandoning their job or quitting. You'd be more than happy to consider them for rehire or reemployment at some point in the future when they feel safe to return to work. You could reassure them that you have a written protection plan at work, and so that the things that you're doing at work and in terms of keeping it clean and social distancing and all those things that would be in your plan are in effect, and that you're enforcing them, and you believe that you have a safe workplace. But people are going to be scared and or maybe scared, and if they are, we understand. Okay, but they also need to understand. And they would also need to understand that a job offer or continued employment, return to work, has been made, and that they likely would not be eligible for unemployment because there's work available for them.
Right, and voluntary resignations aren't covered for unemployment.
Generally not. In these situations, who knows what EDD is going to do? If I make a plea to ED&D that I have parents, I have a child who has a compromised immune system. Who knows what EDD is going to do with that? My only counsel there is that employers should be very cautious or careful, or never try and decide or offer opinions on what EDD is going to do in terms of benefits or not benefits. People say, "Well, is that going to affect my unemployment?" Well, that's between you and EDD. I don't get into advice of saying, "Well, I think you'll probably lose your benefits," or "I think they'll keep your benefits." That's between the employee and EDD, and employers should kind of stay free from that and say, if there's an issue with respect to your unemployment benefits, that is for EDD to decide, and whatever they decide is the way it's going to be. And I frankly don't have an opinion as to whether you're going to get your benefits or not.
Okay. Going further with that, if I have an employee who is too scared to come back to work, but they would like to receive the 80 hours of emergency paid sick leave under the Families First Coronavirus Response Act, the FFCRA, while staying home, is this employee eligible for the 80 hours of pay? If not, and I just wanted to be nice and let them receive the pay, is there a downside to me? And while you're answering that, I am going to share my screen and show the notice that we're talking about. Is it up? Can you see? Okay, perfect.
Yes, that's a poster that everyone should have posted along with all of their general postings. And if you have employees that are now teleworking, you should email them a copy of that notice so that they have it as well. So that notice has been distributed to all employees, those who may be physically at work and those who may be working from off-site. Everyone should receive that poster one way or another.
Great. So then getting to the question, as an employer, can I just let them take that pay? What's my appropriate course of action?
Well, first off, the question as to whether or not they would be eligible for the 80 hours of pay because they say they're too scared to come to work. And the answer to that is no. There are 6 reasons, that make an employee eligible for the 80 hours of pay. And those 6 reasons do not include fear of coming to work. So that employee who expresses that fear and therefore says, I want to apply for, I would like my 80 hours of pay, you should understand that, and you should communicate to them that that they're not eligible because they do not meet one of the 6 criteria. And the 6 criteria are that the employee is subject to either a federal, state, or local quarantine or isolation order related to COVID-19. That does not include our state stay-at-home order. So that doesn't include everybody in the state of California. That would be a specific quarantine order. For example, early on in all this in New York, they issued a quarantine order for New Rochelle or some small city, and that would have applied in this situation. But without a specific local quarantine, that number one reason doesn't apply. The second reason that the employee has been advised by a healthcare provider to self-quarantine. So again, that would be that the employee would come and say, my medical provider has ordered me to self-quarantine because there's a case in my family or for whatever reason. And so that would be a reason. Number three is they're experiencing COVID-19 symptoms and is seeking a medical diagnosis. So they would have to say more than, well, I got a temperature and a cough and so forth. They would have to say that they were seeking a medical diagnosis, and again, provide kind of the name of the provider and contact information for who that provider was. Number four is they're caring for an individual who described above, who is either having to self-quarantine or having symptoms, or it's taking care of somebody. And again, that situation, you should ask for the documentation of who the medical provider is and who is the person that you're providing the care for. Number five is caring for a child whose school or place of care is closed, so that's the school child care provision. And six is kind of a catch-all that the government threw in there that sort of says anything else, but they never defined that. We don't know what that means. So you'll note in there that none of those six reasons say, well, I'm too scared to come to work. So that employee who says that is not eligible for 80 hours of pay. Now, should you want to be, well, geez, these are tough times and the employees are hurting and so forth, and so I want to be nice and I want to pay them the 80 hours of pay. Can you do that? Sure, you can do anything. You can always pay employees. The downside of that is, remember that these payments are, you're going to be able to deduct the cost of these payments from your payroll taxes that you're submitting. And in this case, this one would not be eligible for that payroll tax deduction. And at some point in time, if we get through some of this, I expect there to be some fairly active government audits as to how all these dollars were spent. And I think that employers are going to have to be able to support, okay, why they paid employee A 80 hours of pay and why they didn't pay employee B 80 hours of pay and so forth. And so in this case, your documentation would show, that the employee, was too scared to come to work. You paid him 80 hours. That would not be something that would be a deductible after payroll taxes. So the downside to you is that if you choose to do it, and you can do, you can always pay your employees, you can choose to do it, it does not qualify as something that would be a payment that you could then deduct from your payroll taxes. So yes, you can be a nice employer, but there are pluses and minuses to doing so.
Great. And also, you mentioned documentation.
Yes, documentation.
So yes, yeah, document. Okay, great, thank you. Let's see. So I am about to rehire my employees who I had to lay off when the shelter in place went into effect and my business had to shutter. Am I required to have them fill out all of the new hire paperwork again, including W-4, I-9s, things of that nature?
Well, certainly the I-9. Okay, the I-9, a new I-9 must be completed. And I don't think there are any ifs, ands, or buts about that. And so even if the employee were recently hired as, a month or 2 months ago, a new I-9 should be completed. Whether or not you require them to do all of their new hire paperwork, I think that would be my suggestion. That's a safe thing to do. But again, if it were someone that were hired within 60 or 90 days, you may decide that, filling out new withholding forms and, other things. You certainly might, ask the employee if anything has changed, with respect to their employment information since they were hired. But I think the safe thing to do is to treat them like a new hire and have them complete your entire package of new hire paperwork. But the one critical one is the I-9 form. That is not something that you want to, mess around with, and they should be, so you want to have your I-9 files completely up to date, and so any rehire should complete an I-9 form. Can I go back to the documentation thing for a second? I want to, as I said, I think there's going to be some audits to this at some point in time, or I expect there to be. And so I think that you're going as an employer, that you're likely to be challenged, okay, about any kind of, payments that you made. So that when you are, for example, paying the 80 hours, okay, of sick pay, that you have some documentation someplace of which 6 reasons did you use to make that payment, okay? And so if it's because they had, symptoms themselves or underdiagnosed, it again is the name and contact information with a medical provider. If it is for the schooling, for example, I think that you should have in your record someplace, require an employee, several things. They would include the name of the school or the name of the daycare provider that wasn't available. I think you should provide the names and age of the children somewhere, have that in your records. And I think you should ask for a statement from the employee that there is no one else immediately available to do the daycare, and that they're sort of certifying to that. I think all those things are going to be important to have in terms of documentation to support any payments that you subsequently make, under either of these plans. So, Renee said document. That is absolutely correct. And because I think that there are going to be some fairly heavy duty audits to this, and we're not, if you don't have those records, you're not going to remember why, Johnny, why we paid him 80 hours. And therefore being unable to defend that may very well get you to lose your ability to take that as a deduction. So yes, document.
Excellent. And of course, the speed with which the government moves, it'll be 5 years that you get
Yes.
audited, and then they'll tack on 5 years of penalties. So
Yes, they will.
yeah,
You're absolutely right.
Keep good records. Okay, so let's get back to some employee questions, and then we have one question in our chat I want to get to before we hit the 10 o'clock mark. So we got 10 minutes. If an employee shows up to work exhibiting illness, or they turn out to have a temperature when you take their temperature unbeknownst to them, and I have to send them home, am I required to give them reporting pay, or how would I handle that? Because it's an employee showing up not knowing that they have a fever. Maybe they felt fine when they got up.
Yes, such an employee would be eligible, and you would be required to pay reporting pay to that employee. So employee shows up, and let's say you have a pass-fail on your temperature check, and they fail the temperature check. You would have the responsibility to, reporting pay, which is half their normal regularly scheduled shift, minimum of 2 hours, maximum 4 hours. So in that situation, the employer would be required to pay reporting pay.
Now, what if they knew they were sick and still showed up to work? I mean, clearly, let's assume that they are sneezing and coughing everywhere, and it's pretty clear you didn't get this in the 10-minute drive from home.
I think the safe thing, Renee, is that you may question why they came to work in that condition and so forth and whatever, but you're kind of going down a slippery slope. And so while you may say, well, you should have known better, again, I'm extra conservative in these areas, but I think the fact that they did report to work is going to engage the requirement for you to do reporting pay.
Yeah, I agree. It's 4 hours of pay is safer than a lawsuit.
Yes.
Okay, so can I, as the employer, ask my employees to minimize social gatherings, attending large events, or other high-risk activities currently under our shelter in place during their off time?
I think you can ask, okay, you cannot require. So what I would do if you want to do that, I'd sit down and explain why you think that's important, okay, and ask that employees kind of avoid those situations in which they may be exposing themselves to the virus. But I think it's an ask, not require.
Right. Okay. And let's see, I think I have one more question. And this is about community spaces in offices, so break rooms and things of that nature. How do I, as an employer handle break rooms? Should I, much like hair salons and barbershops are going to be required, get rid of anything that has, high touch exposure, such as, like, let's assume I offer, or I supply coffee mugs and dishes and silverware to my employees to use in the kitchen, so that they're not, using plastic silverware and throwing paper plates away, etc. Should I stop doing that? And then what do I do about things like the microwave and the refrigerator, which are community spaces?
Well, I don't offer myself as a health officer, but I have an opinion. I think in these situations, you first off would have to set up, some type of social distancing in your break room, so that employees are not sitting together and you're able to maintain social distancing. In terms of supplying things like, plastic utensils, and dishware, that's something I wouldn't do at this point in time. I mean, I think I'd stop doing that, and I would include in that, salt, pepper, and ketchup, and all those kind of things that if you typically supply. I would not do that during this period of time. I would tell the employees that they're responsible for bringing their own utensils, their own, plates and so forth, and condiments, and plan to take them with them when they go. With respect to the things like refrigerators and microwaves, I guess I'd have a policy in a refrigerator that, yes, you can certainly use it, but plan to empty it at night, okay? And that we're going to, part of our plan will be to clean it, daily. So I think part of your protection plan would deal with cleaning common space things like refrigerators and microwaves and so forth. But I think engaging in, if you're supplying plates and dishes and utensils and so forth, then I just think that increases that responsibility for you to maintain all this stuff. And I just don't think that's worthwhile at this time. So I would not provide utensils and plateware and ketchup and mustard and salt and pepper, because people are going to be, if you do that, people are going to be using those, containers, and you would then have the responsibility of cleaning them periodically, and so cleaning the ketchup bottle and the mustard jar, 3 or 4 times a day doesn't seem to me to be worthwhile practice, and so I wouldn't do it. I would exclude it for the time being, but I would set up a cleaning system for things like refrigerators and microwaves.
Right, all of the high touch areas.
Yes.
Yeah, excellent. Okay, so we're going to take the last few minutes and get to some viewer questions. So we have one. If anybody has any other questions while we're talking, put it down in either in the chat box or in the Q&A box that's at the bottom of your screen. Okay, so this is the question. I have been asked by a community member who is on unemployment if be allowed to volunteer or do an internship for business while they are receiving unemployment benefits, or can they be hired part-time and still be receiving a portion of the unemployment funds and the extra $600 that they've been getting through the EDD?
Well, first off, with respect to volunteering, I mean, I guess if you are saying that you're offering to go back and volunteer to do some work for your employer, no, you can't do that, because the employer can't have that type of volunteer. If you were saying, well, gee, while I've been terminated and laid off, I want to go volunteer at the Humane Society, that would have no impact on your unemployment. You could certainly do, that sort of thing. One of the requirements they have suspended for unemployment during this period is that you're out seeking employment. Normally, when you're getting unemployment benefits, you need to be seeking employment. That's not a requirement at the time being. So the fact that you were spending your days, helping to clean kennels at the Humane Society, which is not your normal job, is something that you could do, and not have a impact on your unemployment benefits. With respect to, well, my wages are reduced, or I'm earning less, I'm working fewer hours, what impact does that have on my unemployment and the $600? Again, would be my stock answer. That's between you and EDD. Okay, that ED, you're going to report, the income that you're earning would be reported to EDD, and what they decide to do with it with respect to your benefits is between you and them. It may be likely it has an impact, but again, that's not something that the employer has necessarily a view on. So I would deflect that question and not get in the position of, well, you said that it wouldn't affect my unemployment, and it did, and therefore, you're culpable for that kind of advice. So I think you want to avoid that.
Awesome. Great. Let's see. I think that was our only question. Okay, great. Awesome. Well, thank you, Dave. I really appreciate you doing this. I think we covered a lot of areas that are going to be of concern to our employers, especially those that are reopening. If anybody watching has any questions after this, feel free to email us at the chamber, ceo@fortunachamber.com, and we can try and get those answered by Dave at a future point. Great. All right. So thanks everybody for being here, and enjoy the rest of your day. Okay.
Bye-bye.
Thanks everybody. Bye.